Hello, folks. Welcome back to Chris Wyatt Reports. Breaking news from SCOTUS, the Supreme Court of the United States, where in a 6-3 majority decision, they struck down a century-old New York law on concealed carry, one that forced people to go above and beyond the norm. These headlines from the media: the Associated Press, Supreme Court strikes New York gun law, expanding gun rights. Actually, no. They restored gun rights, didn't expand any gun rights. That's a misnomer, Associated Press. How about some facts and not hyperbole? CNBC, Supreme Court strikes down New York gun law, restricting concealed carry in major Second Amendment case. That's accurate. CNN, Supreme Court strikes down New York's handgun law. Also accurate. Well, the Supreme Court today, the 23rd of June, 2022, struck down a New York state law requiring applicants for a license to carry a concealed firearm to have a proper cause to do so, saying that this requirement violated the Second Amendment. Justice Clarence Thomas wrote in the majority opinion, because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. As do I, Justice Thomas, as do I. Well stated. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment. In other words, New York can't simply decide based on today's contemporary view and how people feel about firearms that they can create laws that restrict possession of a firearm today or last year or 10 years ago. You must comport with the Constitution. This, after all, is the purpose of the Supreme Court, to adjudicate whether something comports with the U.S. Constitution. Now, last year, during oral arguments on this, Justice Brett Kavanaugh asked a very simple question and quite relevant question. Why isn't it good enough to say, I live in a violent area and I want to be able to defend myself? That's the real concern, isn't it? With any constitutional right, if it's the discretion of an individual officer, that seems inconsistent with an objective constitutional right, is what he had to say. Now, this ruling is a major victory for gun rights advocates who had challenged New York's restrictive law that makes it a crime to carry a concealed firearm without a license. And in a twist of irony regarding this ruling, the majority opinion is a consequence of applying the Equal Protection Clause of the 14th Amendment, which was written to ensure that former enslaved people in this country were given and protected the same rights. Everyone had equal protection under the law. The left frequently abuses the Equal Protection Clause of the 14th Amendment to extend all sorts of non-existent rights, such as abortion, which is not a right, and will soon likely be overturned by the court, setting aside the illegitimate, unconstitutional Roe versus Wade government extension into the rights of the individual states and territories. Yeah, so they like to reach into the 14th Amendment. So in a twist of irony, the majority, conservative members of the court, and John Roberts, who's not conservative, used the Equal Protection Clause of the 14th Amendment to ensure the Second Amendment. Oh, isn't that the height of irony for leftists? Well, major victory for gun rights advocates and for the Second Amendment, and a small sign of hope that perhaps this country can exist under the rule of law. But this will immediately come under assault. We already see the abrogation of the rule of law by the Attorney General, Meritless Garland, by the Federal Bureau of Incompetence, by Virginia law enforcement officials, Maryland law enforcement officials, in not arresting and prosecuting domestic terrorists who are violating federal law, seeking to intimidate justices by protesting outside their home. This is a felony, not a misdemeanor. You know, the charge that convicted the shaman for sitting in the Capitol building after walking in, invited in by police, and then leaving when politely asked to do so. 40 plus months in a federal penitentiary for a misdemeanor violation. These are felons. They are committing felonies, seeking to intimidate our judicial system. Just like the felons who broke in during the Kavanaugh hearings, broke the doors, sat in the center of the building, locked their arms, and chanted and sang, and disrupted an official proceeding. Oh, wait, that's what the shaman got 3.5 years for. Why aren't they in jail? Well, folks, there you have it. Breaking news from the Supreme Court today, where Second Amendment rights have been upheld in a dramatic decision, drawing back and bringing to heel leftist, out-of-control, constitutional violating states like New York. Perhaps someone can introduce a case to appeal to the Supreme Court about Governor Touch-a-Lot, Andrew Cuomo, Governor Murphy in New Jersey, and Governor El Duce himself, Tom Wolf, here in the Commonwealth of Pennsylvania, who got thousands of our parents and grandparents killed by sending Rona-positive patients in nursing homes. How about some accountability for that now, not just a restoration of constitutionally guaranteed inalienable rights under our Constitution? Hey, folks, if you're not a subscriber, why don't you become one? Hit that button right down there, and you'll get cogent, insightful analysis of events from Africa, around the world, and right here at home in the United States. Cheers, everybody. Thanks for your support. Give us a like on the video.